Hi, my name is Emily Anderson and I'm an attorney at RSH Legal. We get calls to the office all the time from injured workers wondering if they still have time to file a workers' compensation claim. Work comp has some unique deadlines, so let's talk about each of them. First, let's talk about Iowa's notice to employers requirement. Iowa law requires an injured worker provide notice to their employee that they have suffered an injury on the job. This notice must be given within 90 days of the injury. The notice doesn't have to be written, it can be verbal, but we recommend you do it in writing and that you keep a copy of the written notice you provide for your own records. Notice should be given to a supervisor, not a coworker. The notice must include a statement that you were injured and that the injury was at work, meaning you cannot just tell your boss that you're going to the doctor because your back hurts. If you suspect it hurts because of your job, you have to tell your employer that you hurt your back and that it happened at work. When the 90 days starts depends on whether you suffer a traumatic injury that comes on with a sudden event or a cumulative injury that comes on over time. Figuring out the date your cumulative injury begins can be tricky. Generally, the injury date for a cumulative trauma injury is the date on which a reasonable employee would know, first, that there was an injury, second, that the injury was work-related, and third, that the injury affects the employee's ability to work. Even with these guidelines, you should speak to a workers' compensation lawyer if you are having difficulty pinpointing a specific injury date. Next, let's talk about the statute of limitations for workers' compensation claims. A statute of limitations is the final date that you have to either settle your claim or file your claim with the workers' compensation agency. There are two different statutes of limitations in workers' compensation cases, a 2-year deadline and a 3-year deadline. Which deadline applies to your case depends on whether you have received weekly workers' compensation checks. If you have not received any weekly benefit checks, you must file a claim within 2 years of the date of your injury. You could have received medical benefits or mileage reimbursement from the insurance company, but these types of checks do not count as weekly benefit checks. If you have received weekly benefit checks for either temporary or permanent disability, you must file a claim within 3 years of the date the last check was mailed, not the date the check was issued, but the postmark date on the envelope the check came in. Again, getting your medical bills paid or reimbursed for mileage does not count as a weekly check to extend the statute. These deadlines can also be confusing, so if you aren't sure how much time you have left to file a claim, give a workers' compensation attorney a call. If you believe you have waited too long to file a claim, make sure you contact an attorney anyway. Sometimes there is a valid legal exception, and you could file your claim even if the traditional deadline is passed. The only way you will know if one of these extensions applies to you is to speak with a lawyer. To learn more, call us at 1-800-433-0283 or visit our website, fightingforfairness.com.